So hello everyone and welcome, and thank you for joining this, which is a very important subject of health and safety and the management of this area within your business. We have a significant attendance today, and I know it has been of great interest, highlighting how key this area is to all of our businesses. On behalf of the CLA, I'm delighted to welcome you to what I'm sure will be an informative event. My name is Anne Maidment, and I'm the Regional Director for the Southwest and the Chair for today's event. Health and safety is a fundamental requirement of a sustainable farming business and should be regarded as an essential part of farm business management. But it is a fact that agriculture has the worst rate of worker fatal injury per 100,000 of all the main industry sectors, with the annual average rate over the last 5 years around 21 times as high as all industry rate. Our programme is full and topical today, and we are delighted to be joined by CLA partners Safety Revolution. We have speaking first Oliver Dale, who is the founder of Safety Revolution and also a farmer's son. So good afternoon, Oliver.
Good afternoon, Anne.
And secondly, we are also joined by Mia Bambury, who is a health and safety consultant and has been with Safety Revolution for 5 years. I should remind you that today's session is being recorded for future use, including availability to other members. Please may I ask that you keep your microphones and videos muted throughout the webinar. The format for this event is that our speakers will each talk in turn about their area first. Do please feel free to ask questions at any time using the Q&A button at the bottom of your screen. We will then attempt to get through as many as we can in the allotted time, but of course we can look at these afterwards and come back to you if we need to. Please restrict your questions to the session subject. Otherwise, please approach the CLA in your regional office for advice in the normal manner. Thank you very much, and I'd now like to hand over to Oliver to start the presentations.
Thanks very much, Anne. Good afternoon, everybody, and welcome to this webinar. As Anne said, we've got a lot of people here, and we're very keen to receive as many questions as you're able or willing to put forward. This is a complex area of law and of criminal law, and so we're going to try and bring it down to the sort of key points. In a moment, I'll ask Mia to run through the presentation with you, and then I will deal with questions after Mia has completed that. So we're going to concentrate on key points, and then we'll use the Q&A to dig deeper and let the questions go where they will. So I'll hand over to Mia now, and look forward to receiving questions shortly. Thanks, Mia.
Great, thank you. Hello, everyone. Great to be able to speak with you today on what is quite an important area of health and safety, and one that I'm sure touches base with everybody here. So we're looking today at the cost of failure resulting from non-compliance with health and safety law. Now, it comes from a number of sources when we look at this, and given that we've got a short presentation time, as Oliver said, we're looking at the key aspects, the most costly aspects of failure. But this is not an exhaustive list, and of course, each case by case would be taken on its own basis, should that arise. So for us, obviously, we're talking about cost in terms of financial, but this may also be emotional and potentially include the cost of a custodial sentence. So it's a very serious matter that we're looking at in hand. As Anne kindly alluded to, we see that health and safety is an important part of the general management of any business. We obviously look forward to expanding on those areas in particular and taking questions at the end. We'll also look in this presentation on how to avoid some of those costs, as well as highlighting those costs to you. So the first section really to highlight is that when we talk about costs in terms of breaching health and safety, there's two aspects. The first one we're talking about here is criminal. So this is the breach of a health and safety law, so whether that's regulations or the act itself, and these can result in improvement and prohibition notices. So you may be aware, so this is where an investigation would take place and the HSE would impose an improvement notice that states what improvements you must make within a timescale, or a prohibition notice which restricts the activity, the equipment, or potentially a whole site for a period of time until remedial actions have taken place. So those can be put onto any business off the back of a visit from the HSE or the local authority, depending on the enforcing body in your area. You may get unlimited fines following a prosecution. There's the potential for imprisonment up to 6 months in the magistrates' court, in our lower courts, and 2 years in Crown Court. Outside of this, there's also the potential for gross negligence manslaughter, which actually holds up to 18-year imprisonment sentence. Further down, you might have suspended sentences. So this is where you're charged with a custodial sentence, but it's suspended for a period of time. Fees for intervention. So these exist when the HSE may come onto site, conduct an investigation, determine that you have any material breaches. So that is where you are not doing something that the law states you should be doing. And those are charged at £163 per hour at the current rate. That's the 22 to 23 rate. So we can expect that will probably increase again come April. We also have remedial orders. So the court can impose remedial orders associated with a breach in health and safety. And these, any fines or imprisonments, fees for intervention, are non-insurable costs. So it's really important to stress here that when we're talking about criminal law and the fines imposed at court, they are not insurable. So they do come off the bottom line of the business. An example here would be a goat farmer has been fined £180,000 in order to pay £20,000 in costs after pleading guilty to safety breaches after a farm worker was run over and fatally wounded in 2018. They were found to be guilty under Section 2 of the Health and Safety at Work Act. And as you can see, there's quite a significant fine attached to that, and also the additional costs associated with that case as well.
If I may, Mia, it's just worth flagging that you've got Section 2 of the Health and Safety at Work Act there. The HSE will normally take an action under that section rather than the absence of an individual risk assessment. It's more typically the absence of an effective overarching safety management system, which includes obviously policies and procedures.
Thank you. So in terms of the fine structure at court, so it's worth noting at this stage, within health and safety law, nobody has to have been hurt for there to be a court prosecution. It's based on the risk of harm. Although in most cases there has been harm caused, it is not the sole basis for a prosecution. In 2016, the criminal fine structure changed, and the courts were given a new sentencing guidelines. And this basically stated that the fine must be sufficiently substantial to have a real economic impact, which will bring home to both management and shareholders the need to comply with health and safety legislation. In short, that meant that fines awarded at court went up and rose substantially after that fine structure was introduced. The guidance directs the courts to consider the sentencing of offending organisations by examining 4 key areas, and that will determine the level of fine imposed or prosecution in terms of custodial sentence within that case. The first one is turnover. So the initial starting point to determine a fine will be whether you fall into a micro, small, medium or large organisation on the basis of turnover, not profit. Those businesses in the higher category turnovers attract higher fines. They then look at culpability. So this identifies what have you done to mitigate the likelihood of harm arising. So have you got safety systems in place? Have you done everything that was reasonably practicable? What is your evidence to show that you have tried to prevent that from happening? Thirdly, we look at the seriousness of harm risk. So what was the potential for harm? And again, that can range from very low harm in terms of minor injuries, for example, or something more serious where multiple people are affected or could have been harmed by the outcome of that hazard or risk that happened. Then we have the likelihood of harm, and that again just looks at what was the likelihood somebody could have been harmed in those circumstances. So to recap, harm doesn't have to have happened. It is the potential for harm, and therefore that's what we look at when we're considering risk in a business. To look at the turnover example, again, so flagging this is about turnover, not profit. So a small organisation under the categories in the sentencing guidelines, which is a turnover or equivalent between 2 million and 10 million, with potentially a culpability of high to very high, may see a fine of between £12,000 to 1.6 million, subject to how the categorisation at court is determined. That seems like quite a broad category between 12 and 1.6 million. It's worth flagging that we have seen cases where fines of £400,000 or more have been given. So it's really important to consider at the turnover point where you sit. Businesses obviously turning over in excess of 10 million, going into the large and very large categories of organisation would attract even higher fines. The second area where we often talk about the cost to a business. So bearing in mind, we've spoken about the criminal costs under criminal law. These are our civil claims. So these result in compensation to the injured party. This is usually where we hold employers' liability or public liability insurance and result in a payout to that injured party. Compensation for a life-changing injury can range between 5 million and 10 million. So it's always worth making sure that you have the right insurance in place to cover that in the sad event that that does happen. Other costs that we associate with any fines, prosecutions, injuries, any failure to manage health and safety would of course be legal costs. If you do have a compensation payout, you'll see a substantial increase in insurance premiums post-incident. There's obviously the management time, remedial actions, and something that is not always able to put a price to is the brand and reputational damage that can happen off the back of a serious incident. Often it can be very initial stages of an incident and you get the media coverage of that. But more often than not, it can take quite a while for those to get to court. And of course, again, at that period of time, it comes back into the limelight of the incident as well. As we know in our industry, brand awareness in the local areas and across businesses is really important. So it's one thing that, although we can't put a direct figure on, is a definite cost to consider as well to manage health and safety responsibly.
If I may just add to that on the insurance premiums, there are no hard and fast rules. And one of the problems with awareness in this particular area is that most civil cases are settled under strict confidentiality regimes and agreements. So it's often unclear where settlements have ended out, but claims in the order of or settlements in the order of 5 to 10 million are not uncommon for life-changing injuries. And insurance premiums, again, how they're impacted is variable, but typically a percentage of the payout would be the guide for that. And we've seen cases where insurance premiums have risen by typically around 3%. So it can be very dramatic, the impact of insurance premiums, and they can be big numbers. On a multi-million-pound claim, it's not uncommon to see premiums rise exponentially somewhere in the order of maybe £100,000 and £150,000 on a £5 million settlement. And of course, the other challenge there for the insured party is that it is very difficult, in some cases nigh impossible, to find an alternative provider of insurance. So it's kind of one is trapped in that particular situation.
Great, thank you. It's also worth noting that you can be both criminally charged and prosecuted for an incident, as well as have a civil claim. So more often than not, you see a double barrel type situation where you are tackling the case in both the criminal courts and the civil courts at the same time, following a significant incident or a breach of health and safety. On that, therefore, the importance of achieving a higher sense of compliance with health and safety has never been greater for organisations. The outcome of the sentencing standards effectively guide the organisations to show that organisations found to have committed deliberate breaches or flagrantly disregarded the law, or even those that fall far short of the appropriate standard, will be subject to the largest fines. It's almost identifying that those with a high culpability will be subject to the largest fines, and therefore showing that you do have a robust safety management system and that you're properly investing and implementing health and safety within your organisation is your strongest method to mitigating any incidents from occurring, but also being able to show, should an incident occur, that you have, so far as reasonably practical, managed those risks and have a suitable safety management system in place to have mitigated those in the first place. And the outcome of that will be effectively to try and reduce your culpability and likeliness of that incident happening, and thus therefore reducing the outcome of that. So having highlighted the key areas of where costs can arise from falling short of health and safety legislation, what we want to do is also to highlight to you all the great things that you can do and systems that you can have in place to evidence a good safety management system. So in terms of a safety management system, we always advise that these are evidence and documented. So therefore, we've got a health and safety policy there. This needs to be appropriate to the organisation. It needs to be reviewed regularly, annually, by a competent person, and make sure that it is specific to your business and the arrangements are appropriate to your business as well. Business-specific risk assessments and safe working practices. It is not accepted to have general risk assessments and safe working practices. These need to be specific to your business, how you're operating, and these should be shared with your staff as well, so that your safe working practices become a document that staff are engaged with and working with. The regulations also require a provision of a competent person in health and safety for the business. This can be internal or an external third party. Communication, cooperation and consultation with the business on matters of health and safety. It's important that everybody in the business is involved in health and safety, everybody is engaged. It's not something where it can be one individual's sole responsibility. It really requires everybody to be part of that safety culture and be engaged so that they're aware of the health and safety responsibilities on themselves as both employees, supervisors, managers, directors, owners and principals. Accident and near-miss reporting and analysis. It's safe to say it's largely underreported at the lower level of things, and also that the HSE wouldn't take that as there has been no accidents and near misses. They would see that as underreporting. It's important that there is a robust accident and near miss reporting system, and that you are looking at that regularly to identify how to prevent those reoccurring, or in the cases of near misses, preventing those from becoming an accident further down the line. A management system for contractor compliance. Lots of businesses have lots of contractors coming in for multiple operations, ranging from changing taps to tree surgery, and it's important that those contractors are competent to conduct their works, have the relevant safety documentation, but also have the relevant induction, signing processes, etc., whilst they're on the site itself. Accurate and timely records of plant and equipment inspection and maintenance. It's recently been highlighted by the HSE as their new movement towards in agriculture around vehicle safety. but it's long-standing that plant and equipment is usually the largest cause of fatal injuries. So it's really important that that equipment itself is regularly maintained, inspected, and of course in good working order, but also that the environment and the operators are suitably trained and well managed for the safe operation of that plant and equipment. We've got the provision of sufficient resources to effectively manage and deliver a safe working environment. It goes without saying that there is a requirement to invest in health and safety. However, it's also worth noting that usually there is significant payback. So in terms of money invested in health and safety, you're looking to avoid the costs that we have spoken about earlier in terms of criminal costs, civil compensations, insurance costs, but all of those additional indirect costs, cost of reputation as well. So it is important to sufficiently resource that so that you can deliver your compliance to health and safety and strive for best practice. So in avoiding non-compliance costs, some key points, which is not an exhaustive list, but some key things to take away. Periodically conduct a full and thorough audit, so identify where your failings are and putting actions to rectify those. Develop the required systems and procedures particular to your own requirements. So some of those were detailed previously in terms of policies, safe working practices, maintenance records, and so on. Implement the actions identified at audit on a prioritised basis. So again, considering the risk of harm, it's very sensible to look at the highest risk first, those that are most likely to cause significant harm, and work down on the basis of harm and prioritise in that way. It's important to consider that everybody understands we can't do everything immediately, so we have to prioritise it on the basis of harm. Develop and maintain a suitable body of evidence. It's very difficult to prove you have done something if there is no evidence to do so. So effective record keeping and maintenance records, risk assessment reviews, having those written down, all of that written down is your best way of being able to show that you do have a suitable and robust health and safety management system in place. Ensure effective communication and consultation with the whole team to embed and support a proactive safety culture. Again, from our point of view, what we see is where the full team is involved in safety, where it is a key measure for the business, we see a snowballing effect. So the more people that are involved, the more it's considered, and the faster that safety culture grows. Conduct routine reviews to assess the effectiveness and adequacy of control measures. There's a very substantial requirement throughout the regulations and Act for regular review of documentation and your systems that are in place. So that isn't something, it's not a do it once and pop it on the shelf type job. It's something that does need to be come back to and considered more frequently. So where do we see the future of farm and estate safety? From our point of view, an innovative cloud and app-based paperless system, having proactive specialist consultant support, regular engagement with your team, training, information and instruction based on your particular requirements. So that brings us to the end of our short presentation. I'll shortly be handing over for any Q&A that you might have. So we're happy to take any of those questions. But as a finisher, if there for a no obligation consultation contact, please speak to Katie, our client services manager, on the contact details here. I believe they'll also be passed around in the post-webinar contact. But we'd be happy to speak with anybody individually as well about your individual circumstances and how we may be able to assist with that.
Great, thank you very much, Mia. Actually, if you could, if everyone could just turn their videos on so everyone can see the speakers, and then we will get into some questions.
And I've got my video on. Hopefully I'm coming through.
Yeah, absolutely. Just missing Mia at the moment. We'll start with the first question, and just to keep things moving. So we've had a number come in. So we've had one from William, who has made reference to what was discussed in terms of what needs to be done with policies and procedures when it says appropriate to the organisation. What needs to be documented for a sub £1 million to companies with no employees other than the directors?
Well, the key there is the number of individuals. It depends how many directors there are. The threshold of 5 people at which you're required to have documented policies and procedures. And the point there is to make sure you don't trip over it inadvertently. If, for example, you had 3 directors, where you had a couple of part-time employees at some point through the year, or somebody such as a gardener that is going through the books, all of those would be counted as part of the 5. So we often speak to people that say, well, I haven't got 5 people, but when they have a totting up exercise on that basis, they do. To be too clear, below 5, there's no requirement for a documented policy or documented risk assessments. That doesn't mean that you don't have to comply with the Health and Safety at Work Act. You have to be able to show that you were operating in a safe manner. And for example, that if you're using contractors, that those contractors were appropriately qualified or certificated to do the job that they're doing. So that 5 is a key determinant. But to be clear, we would deal with many people who are below 5, but they feel for their overall risk management that they want to have an effective system in place.
Yeah, okay, thank you for that one. That does lead on to another question with regards to employing contractors, which a number of our members would do on their farms and estates. So if you do employ a contractor to do a particular job that you or your employees do not do or are not trained for, does this absolve you from the responsibility or reduce your exposure to prosecution? What do you need to do if you employ contractors to do work for your business?
No, it doesn't absolve you. You are duty bound to assess their competence to undertake those tasks. So you need a contractor approval system, which would look at the type of work they were doing. If it was regarded as high risk work, you would want to look more deeply at what they had. But the very basics are, for example, that contractor has the appropriate insurance in place, and that they have qualifications for the activities that they are going to undertake, and that obviously that they have been able to prove to you that they're competent to do that. So it's very important, and this has been widely tested, that you actually have sight of that, and on Mia's point, that you have the evidence to prove that. It's not sufficient to have word of mouth, or that you've just worked with somebody for 20 years and that you think they're a good person, which they may well be. You have to have the evidence to prove their compliance. The challenge comes if you have an incident or accident and it becomes very forensic. So you've had good relations with a contractor, for example. Unfortunately, all of that falls away because it comes down to the insurers in relation to the respective parties. It becomes very formal, and unfortunately, that's where it can become uncomfortable.
Okay, thank you for that. And if you were self-employed, would this apply to you as well in terms of health and safety regulations?
Yes, so the law applies to either an individual operating on a self-employed basis for commercial gain, or a partnership between a number of individuals, or companies, whether they be a limited company or an unlimited company or a limited liability partnership. And of course, it also applies to trusts. So trustees running trusts for an estate would have the same duties of care effectively as a director running a company.
Thank you. Okay, and what would be your responsibility in terms of training your employees in health and safety?
So the process for training is to identify training needs. They may be identifiable through a number of routes, but essentially you have statutory training requirements. For example, to drive a telescopic handler or a quad bike, there's a requirement in law to have a ticket to do that. There may be other less formal training requirements where through risk assessment you deem it's necessary to train somebody to do something. But there are many statutory requirements that you would be required to address, and those would be normally the priority areas And for example, they would be potentially in high risk activities like operating a chainsaw or a quad bike or working at height, those types of areas. You would normally identify that through the audit process. So again, you either identify it yourself internally through your knowledge of the law, or through networking, or through an audit process. A good audit process should flush out all of the key training requirements.
Okay, and there's a question here about linked to that with regards to your insurance policy. Would your insurance policy become void if you have not ensured your staff have had refresher training for the statutory training that's required as part of their job?
The short answer is potentially yes. I mean, one would need to read the small print of your insurance policy. But for example, normally failure to have something like a fire risk assessment in the event of a fire, for example, could deem your policy null and void. It certainly gives your insurers a get out. The training issue, potentially yes. So in the eyes of the HSE, if somebody has had a, say, for example, telescopic handler ticket, and it should have been refreshed at 5 years, and it hasn't been refreshed, they're technically regarded as untrained. So it's exactly the same as if you were driving a car without a driving license. You're in the same bracket.
Okay, thank you for that. So in terms of reporting, are you required as a business to report any incidents that happen in terms of accidents in your business?
There are certain types of accident and incident that you're required to report under a regulation called RIDDOR. There is a requirement to record all incidents and accidents and near misses in your business. Certain more serious types of incident and accident are should be reported under the RIDDOR guidelines. Those guidelines are quite complex, so I can't sort of pick off headlines with them at this juncture. For example, we always refer very carefully to the guidance when we're deciding what is reportable to the HSE, because clearly if you report something you're not required to report, you may be stirring up interest that you wouldn't necessarily want to stir up. But it is the case that certain types of incident are reportable under that RIDDOR, and failure to report in itself is an offence.
Okay, thank you for that. And leading on from that, in terms of investigations, Ian Anderson has asked, how would you suggest a business should approach an HSE investigation being opened, and what steps ought to be taken at the point that HSE appoint an investigator?
Our approach to advising clients in relation to HSE investigations is always to cooperate fully. And over the 20 years that we've been doing this and we've supported clients through it, including some very serious situations, we have always found that the HSE respond best to clarity, openness, and cooperation. And that's the best advice I can offer. Clearly, there will be situations where the HSE choose to escalate enforcement action, and one would require legal advice and support. And I know Ian, and that is the type of channel that you would go down. But in the short term, in the initial stages, depending on the severity of the incident, we would generally support people in terms of helping them through their early stage relationship with the HSE.
Okay, thank you for that. We just had a follow-up from what you should report in terms, and you mentioned RIDDOR. Somebody has asked, what are the rules about recording near misses?
Well, near misses is in practical terms, what people often say to us is, what is a near miss? So if you haven't, again, we're talking about the practicalities of a farm and estate environment. If you haven't had a culture of reporting near misses, the first thing I'd say is to identify what your top 10 things are that most commonly happen. For example, that could be white van man tearing through the yard and nearly taking somebody out, or it could be consistently tripping over a lead, or it could be something more serious. So why do we record near misses? Because they tend to give a good indication of where an accident or incident may become more serious or may lead to injury. So I would say it's very individual to the business. Identify what you think, what most commonly happens that you feel could lead to injury or damage. And when I speak to groups of guys on farm or estate in a workshop environment, they will usually say to me, well, this keeps happening or that keeps happening. those are the types of things in practical terms I would advise you start to record, because it's not just the recording of the particular occurrence, it's the location, for example, and then when you look back through the records, you start to see patterns of where things happened. And in real, there are practical benefits then in helping you identify perhaps where you need to change things.
Okay.
It's also, sorry, just to add into that, as well as your similar to your accident, as well as your internal recording, the dangerous occurrences section of RIDDOR relates specifically to certain what would be described as near misses. So no harm has happened to an individual, but the fact that that activity or that action's happened is also reportable. So again, as Oliver mentioned, looking very carefully into the RIDDOR guidance to make sure that certain things are or are not reported as well.
Okay, thank you. We have a number of members who are encouraged to open up their farms and businesses for education, so inviting schools and children onto the farm in order to learn about the countryside. What practical advice would you give to someone if they were planning to do that in terms of planning from a health and safety perspective?
It's very important that we get people into the countryside, so and it's very, very important that health and safety isn't a blocker to that. It depends on exactly the type of event. If it's a school trip, for example, you would want to do a risk assessment for it, but you'd also want to talk to the school about their risk assessment and what they've done for the event. Both parties have a duty of care. In practical terms, it's if you're bringing a group of school kids in, it's what are you giving them access to, what's safe for them to be party to and what's not, showing them around, managing them carefully if they're on site with equipment, for example, and access to different areas. Close supervision, very close supervision in conjunction with the school is key.
Yeah, thank you for that. Someone has just put up their concerns around Lyme disease risk for educational visits. I think anything like that, I suggest it would be part of a risk assessment that you would look at any of the dangers or risks when visiting a farm. So yeah,
I'd say absolutely Lyme's disease would be a consideration. I wouldn't rate it personally as a particularly high risk area. It really depends on where you're taking the children, and kids tend to be interested in equipment and plants. So again, consistent with Mia's comments about where most accidents happen, those are areas to watch carefully. We don't see high incident numbers around things like Lyme's disease, but it is a consideration.
Great, thank you. I've got a couple of questions around resources, where to find the information about this. One with regards to contractors. So what a contract approval process looks like, are there suitable templates, and do they provide indemnification if the contractor is not up to the job?
There are various sources of information. The one that's most often cited is the HSE website. There's a massive amount of information on the HSE website. It's almost a question of where do you start if you go there. In the case of what we provide to clients, we provide normally a flow chart that shows how a contractor approval process should work effectively. It is quite an admin heavy job and it's quite laborious, and bearing in mind that you need to refresh it every year, it's almost one of those where you've just got to the end of it and you start again, but it is very important to keep it up. Does it provide indemnity? No, not really. Or it is just one component of your safety management system and of you showing that you've been duly diligent in seeking that information to do to the best of your ability to demonstrate that that contractor is safe. It doesn't remove the contractor's responsibilities. They are still have obligations to operate safely and to take all reasonable measures to reduce risk. It's worth bearing in mind that both parties on site, have that responsibility.
Okay, thank you. And following up from that, with regards to resources, Rebecca has asked, what management systems would you recommend for managing and monitoring compliance, including tenanted and in-hand agricultural and residential properties?
In terms of management systems, we would advocate a cloud-based system, and clearly, this is where we have a vested interest. We would suggest that our management system is the best management system in the farm and estate market for doing that. And as Mia alluded to, it's a question of using the tech to make it as easy and efficient as possible. So a good audit process resulting in a clear policy, clear risk assessments, safe working practices, and all the associated documentation that is then available by management to be easily edited, amended, and then circulated to the team, so that you're getting it around the team and communication is good and it's very contemporary. The information is flowing freely and everybody is engaged. That is the most effective way of evidencing a management system.
Absolutely. And how often would you suggest a business should review their policy for their business? Is it an annual thing? Do you think it's more frequently than that?
Generally speaking, at least annually in a farm and estate environment. Certainly, one would not want to go longer than 12 months. You would look at policy more frequently where there was a particular requirement or an event which required you to review your policy and maybe to tighten it up or to check that it was addressing all of the activities that you were undertaking. If you fundamentally change what you do or you start doing something you haven't done before, you'd normally look at your policy and update it. And the policy then essentially is the cornerstone of laying out whether further risk assessment work is required and if so, where.
Okay, thank you for that. We've had a question from Patrick asking, where does a landowner stand with non-employed people on their land, e.g. members of a shooting syndicate, perhaps, who would be working with power tools, including chainsaws?
Crikey, that's a big question. Yes, so again, one would need to know the nitty gritty, but just on that headline information, for example, if you've got a shoot syndicate coming onto the property, you would really want to make sure that shoot had its own health and safety policy, that syndicate had a policy, and that they had regard for example, use of chainsaws, quad bikes, and that type of thing. So you'd almost treat them like a third party, in some ways like a contractor, make sure that they had policies and procedures in place for that. Failing that, obviously, then it requires the estate, if it's a less formal arrangement, maybe it requires the estate to perhaps look at its own policies and procedures and introduce control measures. But the key is, from the perspective to protect the farm or estate's position, is not to get involved with doing risk assessment activities and work, and thereby implicitly accepting responsibilities where they don't exist.
Yeah, okay, thank you. Well, we're just coming to the end now, and I'd just like to ask Oliver and Mia if you could summarise or perhaps offer a couple of pieces of clear advice for those that might be starting out in this, where they should start, and just a couple of tips from you in terms of what they should do to just start the process of looking at their health and safety policy at home.
Absolutely. Well, Mia, I'll go first on that. I think the key is not to get buried in generating hundreds of risk assessments for every little thing. From our experience, the law doesn't require you to have a risk assessment for everything. It requires you to have a clear understanding of what the prioritization is. You know, what are your high risks, and then address those high risks. And one needs to be able to show that you're addressing them in a logical manner, which is aligned with what the HSC would think and consider to be dangerous. So putting it bluntly, you know, if you're fiddling about with something which is regarded as low risk, but you haven't addressed something that might kill somebody, that would be a big problem. So keep it practical, focus on high risks, and don't generate any more paper than you absolutely need, would be my advice.
Thank you. And Mia?
Yeah, great. I mean, I would have definitely said about the prioritization, but I think also from a practical sense, it's really understanding what activities are taking place, and engaging in others in the business, on the estate, in understanding what those activities are, to ensure that what you are generating, what you do produce, is suitable and appropriate to the activities taking place. So, like you say, being aware if people are using chainsaws or doing something that maybe you weren't first aware of, and taking in, you know, their expertise and getting them involved. Many hands make light work, but it also means you're taking in expert information from people that are out there doing the job.
Brilliant, great advice. Thank you both very much. So Mia and Oliver from Safety Revolution. I do hope that this has been insightful and interesting for those members that can attend. As I said at the start, we will be recording this so you can watch back again to have a look at all the information. And we will be sending around details of Safety Revolution for you to have a further look at what they do. We also have on the slide here, as I'm sure you've seen now, a number of our CLA events that are coming up that might be of interest to you. We have London branch with Anna Jones, who is a Rural Affairs journalist, the Next Generation Conference in Shropshire, our inaugural event for this area, and also our very successful at the moment Agricultural Transition Roadshow plans. We've covered 3 regions so far. We have the South, East and North to go, and I would highly recommend having a look at that one too. So thank you very much for joining us, and we look forward to seeing you at another event in the future. Many thanks.